Okay, so I think that now we are all set. So good evening again. So today's hearing will be opposing Universidad Nacional Autónoma de Honduras versus the University of Neuchatel. And I will now leave the floor to the arbitrators. Okay, so I think that now we are all set. So good evening.
Wonderful. Hello, everybody. Welcome to the round of 16. Very exciting stuff. So my name is Janie Soublière. I am from Montreal, Canada. I will be the chair for our hearing today. I'm joined with my fellow arbitrators, Laurence Maquis, who is also from Montreal, Canada, and Mr. Jacopo Tognon, who is from Italy, from Badosa in Italy. So we are pleased to be your panel to preside on this matter. Before we begin, I would like both parties and co-counsels to introduce themselves. And I would also like you, if possible, to just write your name in the chat so that we ensure that we are saying your name properly and that we have the proper spelling. So the appellants, please, who will speak first? And make sure you get yourselves off mute before you answer the question.
Thank you, Madam Chair. Hello to all of this distinguished tribunal. Good morning, good afternoon, or good evening, depending on where you're located. My name is Donaldo Velásquez, and I, together with my co-counsel, José Zúniga, will represent the appellant in today's proceedings. I'll present the procedure, while my co-counsel will present the merits for this dispute.
Thank you, Mr. Velásquez. And for the respondents, please, who will be speaking first and second?
Thank you, Mrs. Arbitrator. I will be speaking first. My name is Tanguy Ciccone on behalf of University of Neuchatel. I will address the procedural issues of this issue and with my co-counsel Natacha Fayad, she will address the merits of this issue.
I'm sorry, did you say Natacha Fayad? Okay, I don't see your full name on the screen, so wonderful. Okay, thank you, Counsel Fayad, and thank you, Counsel Ciccone. So as you know, you already know the format of this hearing, so there's no need for me to go through the administrative basis of the 20 minutes that you each have. I will, however, point out that my fellow arbitrators and I may cut into your submissions at any point in time to ask questions. So of course, you're expecting this, but I don't want you to be too rattled. Take a deep breath, take the time you need to answer the questions that we ask you. And of course, a reminder to all of you to not speak too quickly. I know when you get out of the gates, you want to speak really fast and say everything you have to say, but certainly your arguments will be far more compelling if we can hear all of them and if you can get them out clearly. So those are just some preliminary issues that I wanted to start with. And other than that, I wish you all, and my fellow arbitrators wish you all good luck. And Laurence, Jacopo, is there anything that you wanted me to add from the outset, or are we ready to jump right in? Good? Wonderful.
Thank you, Ms. President. I'm fine with your presentation. Excellent.
Wonderful, wonderful. Very well, then Counsel Velásquez, please, I cede the floor to you.
Thank you. Before I start, regarding the time management, the appellant would propose 10 minutes, a structure of 10 minutes, starting with the jurisdiction on the respondent side, then moving on to the appellant, another 10 minutes, leaving for a short rebuttal of 1 minute each, then moving on to the merits, starting with the appellant, 10 minutes, and moving on to the respondent for another 10 minutes and a short rebuttal of 1 minute each.
No problem, that's fine. Please proceed. Mr. Velásquez, are you going first then?
No, as I stated, thank you for the word. As I stated, the respondent would be going first. That's what the appellant are proposing.
Oh, I'm sorry. I missed that. Mr. Ciccone, did you have any
yes,
counter proposal to this?
we respectively disagree. As normal case proceedings go, the appellants go first as they intend to challenge some arbitrators today. So we propose that to go with the flow that they go first, then for 10 minutes, and then we go first for 10 minutes, and then short rebuttal of 1 minute each.
Of course, and I must apologize. I hadn't understood that the order had been flipped and Mr. Velásquez's proposal, but certainly we will proceed as anticipated and as the directions had decided. So we will proceed with the appellants stating their case first. Therefore, Mr. Velásquez, I once again cede the floor to you to begin. Thank you.
Thank you, Madam President. Members of this tribunal, good morning, good afternoon, and good evening, depending on where you are. My name is Donaldo Velásquez, as I previously stated, and I, together with my co-counsel, José Zúniga, will represent the appellant in today's proceedings. I'll present the procedure, while my co-counsel will present the merits for his dispute. I will be addressing 3 procedural issues. First, that this tribunal has jurisdiction. Second, that the 2 challenges made on the arbitrator should be upheld, Mr. Vax for lacking impartiality and Ms. Umaima for lacking independence. And third, that the evidence presented should not be admitted in these proceedings. Regarding my first submission, the CAS has jurisdiction to hear the appeal of Mr. Adam. Since according to Article R47 of the CAS Code, all the legal remedies have been exhausted prior to the appeal, and consequently, according to Article R58, the final decision was lodged with the CAS within 21 days of receipt. So the CAS has jurisdiction to adjudicate and decide on the present dispute. Once the jurisdiction has been established, moving on to my second submission, the challenges made against Mr. Vax and Ms. Umaima should be upheld. First, Mr. Vax should be challenged for a lack of impartiality. Let's start with the relevant facts. First, we have Mr. Adam, who has become the visible face of the anti-vaccine movement in Thailand, both nationally and internationally. On the contrary, Mr. Andre Vax works as the president of an NGO dedicated to eradicating diseases, which alone would not be a reasonable ground for a challenge. However, we are basing the present challenge on the Exhibit 7, which gives a legitimate doubt over his independence and his impartiality and bias. Mr. Vax made a wholesale comment against the anti-vaccine movement, which the appellant publicly represents. Mr. Vax stated that they have a free rider attitude, that they are egotistical, uneducated people who only think about themselves. And not only that, but he states that it's everyone's duty to educate these people about the consequence of their stance. Mr. Vax already has a clear bias in this circumstance, and according to Article R34 of the procedural rules of the CAS, an arbitrator may be challenged if the circumstance gives rise to legitimate doubts over his independence or impartiality. According to case law, in Zhuangyang versus Wada, the Swiss federal court ruled that the use of violent language creates the appearance of bias and objective doubts. In that case, it was the context of the appellant, which had a Chinese nationality, and the arbitrator issued 3 comments that were considered as violent language, not as racism, but as violent language that creates the appearance of bias. In the similar case, the comments made by Mr. Vax constitute this same violent language against people from the anti-vaccination movement, and this circumstance allows legitimate doubt about the impartiality of arbitrator Mr. Vax, creating a clear bias for which he should be challenged for a lack of impartiality. Moving on to the challenge against Ms. Umaima, it should also be upheld. According to Article R33 of the Procedural Code of the CAS, every arbitrator shall be and remain impartial and independent of the parties, and shall immediately disclose any circumstance which may affect his independence with respect to either of the parties. Contrary to Article R33, Ms. Umaima presented her revelation 3 months after her appointment, that is, 5 days before the hearing. Not only that, but Ms. Umaima revealed that in the past 3 years, she has acted as sole arbitrator, president, and co-arbitrator in 4 arbitration proceedings to which FIFA was a party, which already constitute doubts about her independence, but not enough for a challenge. However, this representation requested Ms. Umaima about first, the verdicts of the 4 arbitral proceedings involving FIFA in which Ms. Umaima participated, the procedure on these proceedings, and if she was appointed by FIFA in the proceeding where she acted as co-arbitrator. Nevertheless, she failed to provide this information according to the answer 30 and 31 of the clarifications of the case. Nonetheless, the IBA guidelines, which are used as a standard applied to determine both independence and impartiality on conflicts of interest on international arbitration, they state an orange list, which reflects situations on which the arbitrators should disclose potential conflicts. These situations are the following in its section 3.1.3, which it states that within the previous 3 years, if the arbitrator has been appointed as arbitrator in 2 or more occasions by one of the parties. in view of the fact that Ms. Umaima in the past 3 years has acted as sole arbitrator, president, and co-arbitrator in 4 arbitration proceedings to which FIFA was a party. This circumstance described above and the fact that she didn't disclose this information give legitimate doubts and a lack of independence. Hence, we request that the challenge against Ms. Umaima also be confirmed for lacking independence. And now moving on to my point number 3.
Mr. Velásquez, allow me to interrupt you. I have a question with regard to Mrs. Umaima. You've set out very clearly the IBA rules. Now, I'm curious as to how you wish to apply them to a sports arbitration. And in this regard, I draw your attention to the footnote in the IBA rules, which indicates that there is a noted exception for specific types of arbitration, which usually relates to either maritime or sports arbitration. Why should we consider that 3.1.3 orange list applies to us in this very case?
Thank you, Ms. Arbitrator. Yes, the footnote number 5 states that in cases similar to sports arbitration, which they have a closed list of arbitrators, it should not always need to be disclosed. However, the IBA guidelines function as a gap-filling list, for which we should take the IBA guidelines and consider the actual procedural code of the CAS, which in Article R33, it clearly states that the arbitrator should be and remain independent and immediately disclose any circumstance which may affect her independence with respect to either of the parties. So the question would be, why did Ms. Umaima not only disclose this information 5 days before the hearing, but why didn't she disclose about these cases when we requested it till this day until the hearing? Now, moving on to my point number 3 regarding the legal evidence and talking first about the anonymous witness. Anonymous witnesses are not per se prohibited by the European Convention of Human Rights in its Article 6 or by the Swiss Constitution in its Article 29, subsection 2. Nonetheless, in the case that anonymous witnesses are admitted, it must be done as long as certain strict conditions are met. And these certain strict conditions have been stated by this panel in Karim Kramudin versus FIFA, in which it has stated 3 conditions which have not been met in the present admission of the anonymous witness statement. First, that the court should have the possibility to see the witness. However, in this case, neither the FIFA Ethics Committee, the adjudicatory chamber, or even this panel have seen the witness. And consequently, condition number 2, that the witness should be questioned by the court itself, which must check their identities and reliability of the statements. However, this hasn't been done neither. How can we trust a witness that hasn't been seen by the court nor by the appellant, that hasn't been questioned by the court itself or checked about the reliability of their identities or statements? We only have a document. And this brings me to my point number 3, the fact that we cannot cross-examine a document, since the witness should have cross-examined through an audiovisual projection system, which worsens the situation, since the witness was not cross-examined by the court nor by Mr. Adam. And the case law is clear in Karim Kramudin versus FIFA when it states, and I quote, that if the respondent, in this case, is not able to cross-examine the witness, it would be a violation of its right to be heard and to a fair trial, for which the anonymous witness statement should have been cross-examined by the appellant and should be rejected from this evidence. Now, moving on to
I'll stop you on that point just for a second. Understanding that this is a whistleblower, do you believe that the rules might be different in the case of dealing with these witnesses, and also the fact that he might have been heard in criminal proceedings prior? Do you think that that would cure some of the deficiencies that you've pointed out?
Thank you, Madam Arbitrator. And this is why the condition number 3 has been stated, that the witness should not be cross-examined in a normal way as any other witness. But since it is an anonymous witness, it should be done through an audiovisual protection system in which the identity of the witness would be stated confidential, as has been also stated in Cashlet versus Estonia by the European Court of Human Rights. And now moving on to the screenshot, this court has stated in Ricardo Terra Teixeira versus FIFA that proof obtained by means or ways involving violations of human dignity shall be inadmissible. But furthermore, it is not that the evidence was obtained illegally. It is the fact that it was never authenticated, which also has been stated in Karim Kramudin versus FIFA, in which the court has established that in cases where there were messages established, just because a name appears on top of those messages, it does not establish them as authentic, and that evidence to validate who sent those messages must be established. I would like to ask the panel, what proof of authenticity has FIFA provided to these Telegram conversations? FIFA pretends that this tribunal admits messages sent by an anonymous source when they have failed to identify the source or its reliability, failed to identify the supposed date of the Telegram conversations, and failed to prove that these messages were even extracted from Mr. Adams' phone, for which we request, for all these facts and legal background presented, we request respectfully from this panel that they declare that the case has jurisdiction, that the arbitrators should be challenged, and that the witness statement violates the right to a fair trial, and the Telegram message be deemed inadmissible for a lack of authenticity. Thank you very much.
Thank you, Mr. Velásquez, for your very succinct comments. Thank you very much for that. Mr. Zúniga, please proceed.
I just have a question, Madam Arbitrator. The order we agreed upon was that the respondent would follow regarding jurisdiction. Am I correct?
Yes, indeed.
Yes. Yes, indeed. Sorry, in my first hearing, everybody did one shot. So please, Mr. Ciccone, okay. Mr. Ciccone, please proceed.
Thank you, Mrs. President. Honorable member of the panel, during the following 10 minutes, I will be addressing 3 issues in relation to the procedure. I will briefly begin by addressing why the case has jurisdiction to hear the present appeal. Then I will continue by explaining to you why the challenges against Mr. Vax and Mrs. Umaima should be dismissed. And then I will finish by demonstrating how the evidence used during the FIFA appeal proceedings is admissible. As this is a simple case of infringement to the FIFA Code of Ethics, we will not review the facts already detailed by the appellant. Instead, we'll touch upon the core issues of this case to persuade you as to why Mr. Atom must be sanctioned for the sake of football. As to the first issue, we submit that the CAS has jurisdiction to hear appeals against final decision of Sports Federation based on R47 of the CAS Code. The appeal decision is a final decision and subject to appeal before CAS according to the Article 58, paragraph 2 of the FIFA statutes. Hence, we submit that there is a valid arbitration argument and that all internal legal remedies have been exhausted. Finally, as both parties appeared before the FIFA Appeal Commission and that the appeal decision specifically indicates a legal action to the CAS, we do not dispute the jurisdiction of the CAS as it would be contrary to the principle of good faith and to the Latin principle of venire contra factum proprium. Now to the second issue, the challenge of Mr. Vax and Mrs. Umaima. We should remind that the panel was already constituted on the 29th of November 2021. At this time of the appointment, it was a known fact that Mr. Vax was the president of an NGO for eradicating diseases, and yet he was not challenged at that time. In relation to the Tognon case, as well as the established jurisprudence of the Swiss Supreme Court, we would like to remind that parties have a duty to demonstrate a degree of curiosity. The issue here differs from the Tognon case in the sense that there was only one comment from Mr. Vax that was even more publicly available and not 200 tweets to go through. It would make sense to check in the first place the LinkedIn profile of Mr. Vax, as it is a professional media that is used by many arbitrators and lawyers. With that, a simple Google search right after the appointment of Mr. Vax would have been enough to discover the Exhibit 7. Therefore, we submit that the appellant has breached his duty of curiosity in this case, and that in consequence, the challenge of Mr. Vax is evidently late, according to the R44 of the CAS Code that provides that any challenge should be brought within 7 days. Moreover, even if this honorable panel should find that the challenge brought by the appellant is not late, the single LinkedIn comment doesn't show any discriminatory behavior or stereotypes toward unvaccinated people. The use of words such as uneducated or selfish is not in itself insulting. On the contrary, we argue that the comment is a structured argument and that simply encourages people to get educated and vaccinated. That's why we see no problem with it. Even more, the case of Mr. Atom is a case of bribery and has nothing to do with COVID vaccines. Therefore, we submit that the one LinkedIn comment is not sufficient per se to call into question the impartiality of Mr. Vax. Now, regarding the challenge against Mrs. Umaima, We do not dispute the fact that she has acted as a sole arbitrator, a president, and a co-arbitrator in 4 arbitration proceedings in the last 3 years, to which FIFA was a party. On the contrary, we thank Mrs. Umaima, who is merely being transparent by disclosing these facts. Furthermore, we submit that this panel is not legally bound by the IBA guidelines on conflict of interest due to the specific nature of sport arbitration. To put things into perspective, according to CAS statistics, football cases are predominant out of the total appeal proceedings before the CAS. Therefore, it would make sense that Mrs. Umaima, being a football arbitrator, could be appointed regularly on football cases, and that FIFA would also regularly be a party to these proceedings. Likewise, according to the Swiss Supreme Court jurisprudence, for example, our legal authority number 10 from 2001, past or prior business relationships are not problematic per se, unless some time remains. As to the former in-house FIFA counsel that recently joined Mrs. Umaima's firm, we argue that this fact is not relevant in the present case, as he joined Mrs. Umaima's firm as an associate, which means he's only an employee and by extension not a partner of Mrs. Umaima's firm. We argue that his position within the firm is therefore not sufficient to lead to a conflict of interest. That is why we are perfectly confident that no ties remains, as Mrs. Umaima is sufficiently professional to remain impartial when assessing a FIFA case. To sum up, we have now demonstrated that the challenge against Mr. Vax is evidently late, and that both challenges should be dismissed in any case.
Mr. Ciccone, allow me to interrupt. I have a related question that I asked your friend on the other side about Mrs. Umaima's challenge regarding her previous roles as arbitrator. Never mind the fact that the IBA rules are soft line, we're well aware of them and they may not apply in the present case. I am troubled by the fact that there was no answer from her and she refused to disclose, as was requested by Mr. Atom's team, the results and her decisions. Is there any legal basis on which we can rely as tribunal, either to take these into account or rest assured that they do not taint her independence and impartiality?
Yes, thank you for your question, Mrs. Arbitrator. If you're looking for a legal authority, in the Tognon case, the Swiss Federal Tribunal clarified that IBA guidelines may, in fact, inspire sport arbitration proceedings, even if they are not binding in themselves. Therefore, we submit that the non-disclosure or the late disclosure is not enough to reach the threshold of partiality of Mrs. Umaima.
Allow me to rephrase, I might not have been clear. I'm looking for a legal authority to allow us to rule on the fact that Mrs. Umaima did not agree to the request of her previous decisions that was requested by the other side. Not the fact that she acted as arbitrator, but the fact that she has not, to this day, sent the awards.
I'm sorry, could you reformulate the question?
I understand your position about the IBA guidelines. I'm more troubled by the fact that Mrs. Umaima, despite requests to do so, has not turned in or has not made available the awards in which she acted previously as arbitrator.
Thank you. We believe that Mrs. Umaima is not obliged to answer to these questions, and that she was also being transparent by disclosing the fact that an employee joined recently a firm as soon as it became official. So we think Mrs. Umaima is here being sufficiently transparent as to her requirement as an arbitrator. Thank you.
Thank you very much. Please proceed.
May I ask a question, Mrs. President? Janie, may I ask a question to
Please
Mr.
go ahead.
Yeah, thank you very much. No, of course, I listened to your last question, Mr. Ciccone, of Laurent question, but indeed, these are a thing that I don't really understand, but it's the following. So you, well, probably it's my fault, but if I well understood, you affirmed that IBA guidelines per se are not applicable. Well, per se, why? In the sense of why you really think that these IBA guidelines should not be applicable? But normally, just to say, the scholars or anyway in the practice, we believe that it should be, or anyway, if you can explain me a little bit better, but probably it was my fault, I didn't understand properly. If you can explain me why you really think that these guidelines are not applicable.
Yes, thank you. Thank you for your kind question, Mrs. Arbitrators. We do think that we can, of course, be inspired by IBA guidelines, but they are not mandatory, which means that we may be inspired, and the Swiss Federal Tribunal rightfully stated that it could be inspired in sport arbitration, but not legally binding and
like a sort of path, You can follow them, but you're not binding by them.
Exactly, like the procedure.
Okay,
yeah,
very clear. Thank you very much. Very clear.
So I will now touch upon the third issue and explain to you why there is no right to cross-examine the anonymous witness, why there is no breach of the appellant's personality, and how there is a preponderant interest to admit the evidence. First of all, the Article 46 of the FIFA Code of Ethics clearly states that proof that has been obtained by means or way involving violations of human dignity should be rejected. We can draw a direct parallel with the notion of the Swiss public order, as the Swiss public order is only violated in the situations of an untenable contradiction with the sentiment of justice. In consequence, that means that all illegal evidence is not necessarily inadmissible, but it should be in a particular contradiction with the sentiment of justice. Regarding the Exhibit 5, we submit that the use of only a few hacked telegram messages is not in contradiction with the sentiment of justice, and that is therefore admissible. And we refer to the Valverde case versus Ciccone. Moreover, regarding the Exhibit 4, the witness statement was already part of the file in the FIFA appeal proceedings, and the witness was not present during the procedure before the ethics committee, nor before the appeal committee. According to the Teixeira case, this evidence must then be treated as a documentary evidence instead of a witness statement. Therefore, the evidence is admissible, even if the whistleblower could not be cross-examined in the appeal proceedings or before the present case panel.
Excuse me, I'm going to cut you off to ask you a quick question. How is it, and what is your understanding of the difference between documentary evidence and witness evidence? And how should the panel treat it differently in this case?
I'm sorry, could you repeat the question?
What is the distinction? You've made a distinction in your submissions regarding documentary evidence and witness statement evidence. So what is the distinction between the two, and how would you like us as a panel to treat the evidence that you submitted to us?
Indeed, the distinction is clear because there is no right to cross-examine a documentary. Of course, there are different proofs. You can cross-examine and interrogate a witness, but you cannot as a documentary evidence. The difference also relies in the appreciation of the evidence, but as this is the admissibility part, I'm dealing with the admissibility, and we submit that it should be admissible under documentary evidence and not as a witness statement. Of course, we would also have loved to integrate this witness, and that's why we could not.
Thank you for your answer, please.
Now I will touch upon the issue of the appellant's personality. As you know, FIFA has the duty to preserve the integrity of football. Corruption is a cancer that FIFA has been eradicating for many years, and this costly battle against corruption is in one hand a private interest, the private interest of FIFA not to have any corrupt official inside the organization, and on the other hand, a public interest for the Swiss authorities to punish corruption in all its forms. We refer to the we refer in particular to the Valverde case, where the fact that Switzerland was a part a party to the international convention outweighs the use of illegally obtained evidence. In the case of corruption, Switzerland is a contracting party of the United Nations Convention Against Corruption, as well as the OECD Convention Against Corruption. In any case, we submit that the private and public interest to fight corruption will be preponderant to any breach of the appellant's personality. Last but not least, we argue that the evidence is credible. The appellant failed to demonstrate how the telegram messages, Exhibit 5, were manipulated. Such assertion that is not supported by any credible evidence is mere speculation and should be dismissed. We understand that the appellant relies on the Manchester City case and that the present case differ because the telegram were not authenticated. In our case, we argue that the messages could have been authenticated if only the appellant had submitted an alternative telegram message, but it was not the case. And finally, we remind you that in the Manchester City Award, the evidence was deemed admissible, not only because of the authentication of the messages, but also because of the preponderant public interest, which you have touched upon just before. Now that I have demonstrated to you how the evidence is credible, I would like to conclude that this honorable panel should dismiss the challenges against Mr. Vax and Mrs. Umaima and admit all the evidence used on the FIFA appeal proceedings. With that, the respondent rests for the procedural issues. Thank you.
Thank you, Council Ciccone. Council Velásquez, I will give you your rebuttal opportunity. Thank you.
Thank you, Madam Arbitrator. The respondent started his arguments regarding Ms. Umaima by stating, Ms. Umaima has been very transparent. I'm going to repeat this. Ms. Umaima has been very transparent. How can an arbitrator be stated to be transparent when she didn't disclose this until 5 days before the hearing and 3 months after she should have? And this at its very minimum could be interpreted only as bad faith. And number two, she never provided the information we requested as to the verdicts of the 4 arbitration proceedings to which FIFA was a party, the procedure, and if she was appointed by FIFA. This alone gives and creates a legitimate doubt about her independence and why she hasn't disclosed any of this information. And regarding the Telegram conversations, how can we demonstrate something that never exists? The respondent is failing to meet Article 49 of the FCE, which states that the burden of proof relies on FIFA, for which they have failed to prove the authenticity of the forgery on these Telegram conversations. Thank you very much.
Thank you, Mr. Velásquez. Mr. Ciccone, rebuttal, please.
Thank you, Mrs. Arbitrator. Of course, we would like to remind the appellant that Mrs. Umaima has no obligation whatsoever to comply with their requests, and that in fact, regarding the cross-examination, we are just as frustrated as the appellant for not being able to cross-examine the whistleblower. This person obviously knows many things about the local match fixings, the match fitting in Harland, and FIFA would be interested in, of course, cross-examine this witness. We submit that this evidence, the witness statement, is a documentary evidence that has the lower standard regarding his admission than a witness cross-examination that has a much higher degree of admissibility. That is why finally we submit that this evidence should be admissible. Nonetheless, the appellant says. Thank you very much.
Okay, thank you to both teams for your submissions on the procedure. We will now proceed on the submissions on the merits. And now, Mr. Zúniga, it's your turn. Please proceed.
Thank you, Madam President, for allowing me the use of the floor. Greetings to the arbitral tribunal, the counterpart, and others present. My name is José Zúniga, and alongside with Donaldo Velásquez, we are representing Mr. Oliver Adam, former president of the Football Federation of Thailand. Throughout the course of my arguments, the panel will realize that the appeal decision was not rendered in accordance with what the applicable law dictates for the following grounds. Primarily, we would like the panel to cancel the sanction imposed over Mr. Adam due to the simple fact that Mr. Adam never breached Article 27 of the FIFA Code of Ethics. Alternatively, if the panel still considers that the offense has been proven we would like the panel to declare the evidently and grossly disproportionate sanction imposed over Mr. Adam and proceed to amend it. In light of what I just mentioned, let me take you through the facts of the case, and let me start by acknowledging that the fight against corruption may be arduous and it may require strict rules. However, both rule appliers and rule makers must begin by being strict with themselves. I make this introduction for a better understanding on how the elements of bribery developed in Article 27 of the FIFA Code of Ethics were not met, not even proven by FIFA. The appeal committee rendered
Mr. Zúniga, I'm going to cut you off right now. I think you're citing a case. Can you please tell us what's your authority on that citation?
I'm not citing a case as of now, right now.
Okay.
Nope. Yes.
Thank you. Please proceed.
That's okay. The appeal committee found Mr. Adam of breaching Article 21, which is abuse, Commission, 25, which is abuse of position, and they were both materially absorbed by the breach of Article 27, which is bribery. They based this decision upon a single anonymous whistleblower statement, which showed some serious inconsistencies during his testimony. This would be exhibit number 4 of the case, regarding an anonymous person who allegedly was present during a business dinner held between the former president of the Football Federation of England, Mr. Daniel Kaiser, and Mr. Adam. Now, we do not know how FIFA got to the conclusion that Mr. Adam had dinner with Mr. Kaiser when this anonymous whistleblower whistleblower person in its paragraph 13 clearly stated that he identified Mr. Kaiser, but he did not recognize the other 2 people who were Mr. Kaiser had dinner with. This is a matter rather astonishing, because the weighing of evidence plays a major role when deciding upon a comfortable satisfaction standard, just as was cited in the matter of Andrei Kurniv versus International Olympic Committee. The more serious the allegation being considered, the greater is the degree necessary to achieve the requisite of comfortable satisfaction to prove the commission of the offense, something which FIFA clearly neglected to do so. They even based their appeal decision upon a screenshot taken by a hacker, allegedly, from Mr. Adams' phone. The respondent said that the appellant failed to prove the authenticity or not authenticity of this screenshot, but according to a case cited by even the respondent, Ricardo Terra Teixeira versus FIFA, the case hold that the person who provides the evidence must provide also the authenticity. And this is heavily stated in the FIFA Code of Ethics regarding the burden of proof, just as my colleague Donaldo stated. My colleague Donaldo stated the legal character of both this evidence, but we recognize the novel character of this panel. So let's assume that all evidence is admitted by this tribunal. However, does the evidence provided by FIFA carries, if any, sufficient evidentiary weight to demonstrate to upon a comfortable satisfaction standard that Mr. Adam infringed Article 27 of the FIFA Code of Ethics? With the indulgence of the panel, let me develop the elements of bribery found upon Article 27 of the FIFA Code of Ethics, which were considered in the case of Ricardo Teixeira versus FIFA. The tribunal will deduct that no infringement was made by Mr. Adam. First, a person bound by the FCE, and a counterparty must be a person within or outside FIFA. Totally undisputed, however, totally insufficient on its own to provide that Mr. Adam infringed the FIFA Code of Ethics. The second element is that this official must have accepted, given, requested, or solicited an advantage or undue pecuniary. Let's assume that the evidence, the whistleblower statement, is admitted by this tribunal. However, not a single paragraph demonstrates that Mr. Adam received, gave, or attempted to receive an advantage. One of those inconsistencies regarding the whistleblower statement is that a shiny watch, which looked expensive, was given by Mr. Kaiser to Mr. Adam. However, this anonymous person did not recognize the brand of the watch. Might as well be an overpolished $10 watch. Therefore, this element is not fulfilled. Element number 3 is that
I'm going to cut you off there again. Sorry, Mr. Zúniga. Do you think the value, the monetary value of the watch would make a difference in your argument? So if it was a $10 watch from a store and as opposed to a Rolex?
Yes, definitely. Regarding the undue pecuniary or undue advantage, it's defined as something in which the person is not entitled to receive. the value of the gift plays a major role when deciding if the person committed bribery. This might be just a single gift or something trivial. In this case, we do not know the brand of the watch, so I don't know how the FIFA concluded that this had significant value. The third element I was about to develop was that there must be an undue advantage or undue pecuniary at stake. Again, let's assume that the anonymous whistleblower statement is true. And the advantage that the counterparty will argue is the potentially friendly football match held between the football federations of Big Land and Tiny Land. When Mr. Kaiser and Mr. Adam allegedly were discussing this, Mr. Adam clearly stated that a 50-50 split on the broadcasting revenue will happen. It was Mr. Kaiser who said that he was willing to waive his broadcasting rights, Big Land's broadcasting rights. But it was always Mr. Adams' intention to split the revenue. What it is not deducted from the case is whether Mr. Adam accepted, rejected, or remained passive about this offer.
Mr. Zúniga,
yes.
I apologize I cut you off. I would like to follow up on our president's question about the value and what may we consider or not as an advantage. You have not spoken to the fact that there's an invitation to stay for an entire week to discuss matters which presumably could have been discussed, perhaps not in the course of a week, with business class tickets, very expensive restaurants, and should we decide that the evidence is admissible, of course, some expensive meals as well. Would that not be sufficient and not just the watches that we were discussing earlier?
Totally. I see your point. Let's remember, according to clarifications of the case number 6, that Mr. Adam and Mr. Kaiser has a professional relationship. And Mr. Kaiser, according to exhibit number 1, invited Mr. Adam to discuss business opportunities. And which were these business opportunities? Mr. Kaiser took Mr. Adam to football facilities, training facilities, touristic points. This was essential for Tiny Land, one of the smallest football federations of the world, whereas Big Land, being one of the biggest football federations of the world, Big Land helped Tiny Land to expand the culture of football. Those were the business opportunities Mr. Kaiser and Mr. Adam wanted to discuss, as well as the potentially friendly football match. Based on these considerations, the tribunal should be completely satisfied that no elements of bribery were fulfilled, because not even the quid pro quo element, which is the last element, that this official, the undue pecuniary or advantage received by this official, and the action by the official must be proportionate. There is no advantage regarding Mr. Adam on what will he receive by Big Man winning the 2026 World Cup bid. And in view of my time that will expire, I just want to ask for just 1 extra minute, please. Thank you, Madam Arbitrator.
Yes, no problem.
Lastly, if the tribunal held that the elements of bribery were proven, I would like to declare that the sanction was evidently and grossly disproportionate on the following mitigating factors. Number 1, the position of the perpetrator. Mr. Adam had only been serving for only 2 years as a president. I'm not saying he was permitted to act reckless, but it shows how inexperienced he is in these matters. The gravity of the act. Had Mr. Adam not voted for Big Land would have still won the election because another 106 football federations stood by him, and FIFA failed to prove the amount of money received by Mr. Adam. Therefore, the sanction should be amended to a reprimand or a 3-year sanction of participating in any football-related activities. Based on these conclusions, I ask the panel to declare itself competent of knowing the person's decision, to declare Mr. Adam innocent of infringing the FIFA Code of Ethics, and to declare the grossly evidently sanction imposed over Mr. Adam and proceed to amend it. Thank you very much. I remain attentive to your doubts.
Thank you, Mr. Zúniga. Ms. Fayad, are you ready to proceed?
Ms. President, may I ask a thing to...
Please.
Yeah,
please,
but
please.
very quickly. No, I appreciate your final pleadings, but and I was wondering about the so-called grossly disproportionate to the sanctions, because normally this is one of the most important topics where we manage now in the proceedings like this one, exactly. And correct me if I'm wrong, but let's assume, for instance, that really the sanction was disproportionate. Do you have an idea on which way it should be amended? Or maybe you told me and I didn't get the number.
Yes, totally. The sanction should be
so
amended
15 years
because
was starting. 15 years was the starting sanction. So which is for you? What should be the correct one? Your idea?
yes.
In case of course, it was a breach.
Definitely. I think there must be a reasonable balance between the kind of misconduct and the sanction, given the mitigating factors. In the present case, a 3-year ban on taking part in any football. Yes.
Yeah.
In taking football in any football-related activity must be sufficient, or even a reprimand or a warning, given the mitigating factors.
Okay. Thank you very much. Thank you very much, Mr. Zúniga.
Thank you. Ms. Fayad, Université de Neuchatel, please proceed.
Thank you. Very good day to members of the tribunal and colleagues here. Do you all hear me well? Perfect. I now present the arguments on the merits on behalf of the respondent FIFA. So my focal points will be that the conditions for a violation of Article 27 of the FIFA Code of Ethics 2018 were met, and that the sanction was proportionate. So before addressing the breach of Article 27 of the FIFA Code of Ethics, I would like to say that I agreed with the Appellant's counsel on the matter of applicable law, and the Appellant is bound by the FIFA Code of Ethics 2018 and should be held accountable in view of this version of the code. So allow me now to address the merits of the breach of Article 27 of the FIFA Code of Ethics. I would like firstly to say that the conditions of a breach were met. Mr. Atom accepted the offers given by Mr. Kaiser as an advantage by firstly accepting to fly to Bigland in an all-inclusive luxurious trip. So including the luxurious hotel rooms, the fancy Michelin-starred restaurants, champagne, spa access, and extravagant parties, and in other words, everything and anything paid by Mr. Kaiser. Secondly, by receiving and accepting expensive watches, and as stated by the cast panel in the Al-Kamali case, the value of the watch actually doesn't matter for a breach of the FIFA Code of Ethics and for a bribery to have happened. And thirdly, by receiving the promise of hosting a match between Tinyland and Bigland in Tinyland, all the while keeping all the revenue, which is very unusual and which profits to the appellant's wife, who is a major shareholder of the only football broadcaster in Tinyland. It is actually not decisive whether the advantages were accrued, as seen in the Amos Adamu versus FIFA case. So the fact that the match didn't take place or that he gave back 20,000 francs because of the fear of prosecution doesn't change the fact that Mr. Atom was actively bribed. The reimbursement, which occurred more than 2 years after the acceptance of the advantages, should even be perceived as an admission of guilt by Mr. Atom. So the gifts and offers to Mr. Atom were incitements and rewards for his voting and support for Bigland in the 2026 World Cup election. We can see that using Exhibit 5. In the Telegram messages, Mr. Landers says in his last message, "We cannot draw back now." It means that an agreement was made between Mr. Atom and Mr. Kaiser. And it is undisputed that Mr. Kaiser asked for Tinyland's support in the election for the 2026 World Cup location, according to Mr. Atom's testimony in the FIFA disciplinary proceedings. Concerning the witness statement, we can see that Mr. Atom is easily identified when we look at paragraph 19 of this statement. It is said that Mr. Atom actually said, "We really appreciate the offer of a match between our national teams in Tinyland." It proved that Mr. Atom was actually in place in the restaurant with Mr. Kaiser when those watches were given. So I would like to remind the honorable panels that it is also an undisputed fact that during the same year, in 2016, Mr. Kaiser invited football officials from several other delegations, including medium-land and hardland, and those trips were actually made in the exact same circumstances as the trip made by the appellant. In 2018, criminal proceedings happened in hardland, and it was issued by the judge that the officials sold the vote of the Federation of Hardland to officials from Bigland in exchange of a luxurious trip and gifts. Mr. Kaiser in these proceedings was convicted of bribery. So the evidence used in this criminal proceeding are the same used by FIFA, including the witness statement. As we know, the standard of comfortable satisfaction is widely applied by CAS panels in disciplinary proceedings. So it is a standard that is lower than the criminal standard of proof beyond reasonable doubt, as seen, for example, in the Foussi Mallory versus FIFA case. And so the standard of proof beyond reasonable doubt was met in the criminal proceedings in hardland, and it is subsequently met in the CAS proceedings. Lastly, I'd like to add that the results of the votes were very tight. So there were 104 votes for losing land versus 107 votes for big land. Hardland, medium land, and tiny land all voted for big land, and they were all bribed by Mr. Kaiser. If Mr. Kaiser didn't offer those gifts in exchange of the votes, big land would have probably lost, and it shows that the bribery actively influenced the result. Now, regarding the proportionality of the sanction.
Before you go on, I do have a question. Sorry, both Laurence and I had a question. Laurence, did you want to go first? Please, Ms. Maquis.
Madam President, I defer to you.
Okay, I have a question, and I'm going back right to the beginning where you said that Mr. Adams' return of the $20,000 should be perceived as an admission of guilt. Those are your words, are they not?
Can you repeat?
You said that the fact that Mr. Adam returned the $20,000 should be perceived as an admission of guilt.
Yes.
That's what you said. Okay. So this is your opinion, or you have an authority or legal precedent to back that up, or if you can explain that statement, it would be useful for the panel.
No, that is my opinion. I think that the reimbursement may be perceived as an admission of guilt because it happened only when the prosecutions happened before the hard-linen judges. So it was because he feared to actually be held accountable of his actions that he gave back the 20,000 francs.
Okay, thank you very much. Arbitrator Maquis, did you have a comment as well, please?
I did, thank you. Thank you, counsel, for your argument. You cited and you referred us to many cases, the Ali Kamel case, and then the second case you referred to regarding the promise of a match. Could you please remind me what that case was? Was the Amos Adafi case? Am I correct?
The Amos Adamu, I cited.
Adamu.
Yeah, I cited to say that that it is not decisive whether the advantages were actually accrued or not. Yes.
Okay, I remember. So how do the cases, the facts in that case are related and can be applied to our present matter?
In the Amos Adamu case, he's in an official, a football official who received. I'm sorry, I just have a minute to look at my notes. May I have?
Well, it's okay. If not, you can refer by note to the tribunal at a later time. I don't want to hold up with.
All right.
Thank you.
I'll come back to it.
Okay, then okay. We can proceed. I'll let you proceed with your argument. I believe you were going to the grossly disproportionate nature of the sanction, and we'll listen to you. Thank you.
Yes. With regard to the scope and duration of such ban, the FIFA Code of Ethics sets forth minimum and maximum limits for certain infringements, but not a maximum limit for the most serious infringements. In this respect, bribery is considered the most serious offense in view of the damage it causes to the image of football. Notably, in recent years, FIFA's image has been seriously damaged by repetitive bribery scandals involving officials affiliated to it, as we all know. And in light of these events, FIFA's judicial bodies must impose sanctions that will dissuade others from acting the same and that will restore the public's trust. And as CAS panels have rightly expressed in many awards rendered, for example, the Kwesi-Nyantakyi case, to name just one, it is essential to demonstrate no tolerance against all kinds of corruption and to impose sanctions sufficient to serve as an effective deterrent to people who might otherwise be tempted because of their greed to adopt improper conduct for their own personal gain. And I'd like to say that we took into consideration all matter in the subject. Mr. Atom didn't cooperate with us once, given the committed acts, the lack of remorse or confession of the appellant, which are aggravating factors as stated in the CAS decision Emmanuel Brifa versus UEFA. And given his high position, the sanction must be severe and is therefore proportionate. Considering that similar sanctions and even life bans were already imposed in corruption cases, a 15-year ban is not disproportionate. We can see that in the FK Pobeda case and the Oleg Orikov, where life ban were imposed, or even the Mwamelo or Kwesi-Nyantakyi, where the CAS actually reviewed the sanction and decided on a 15-year ban instead of life ban. So the panel deemed a 15-year ban proportionate, just like in our case. So in other words, the sanction is proportionate to the offense since it doesn't exceed what is reasonably required in the search of a justifiable aim. So I would like, lastly, to remind you of the de novo power of the CAS. So the CAS panel is not bound by other case law and has full power of review. However, that power is limited to the condition that the sanction is grossly disproportionate, as stated in the Guzman case. And as demonstrated before, the sanction is not proven to be grossly disproportionate. And therefore, CAS doesn't have the power to change the sanction imposed. And with that, I thank the tribunal for its time, and we are at its disposal should any clarification be needed. And with that, the respondent rests.
Thank you kindly. We will hear the rebuttals now from both teams. So Mr. Zúniga, for the appellants, please.
Thank you, Madam President. Regarding the Amos case cited by the respondent, Mr. Adams actively participated in a scheme of bribery. He even involved his own son in this scheme of bribery. It is not deducted from the case, from our present case, whether Mr. Adams actively participated, rejected, or remained passive about this alleged bribery scheme. It is rather preoccupying that FIFA does not take into account the reimbursement made by Mr. Adams, given that it is a mitigating factor according to Article 9 of the FIFA Code of Ethics. Plus, the reimbursement was made 6 months before the investigation, FIFA's investigation, which shows the good faith. To conclude, just because FIFA cannot control its internal problems, this does not imply per se that Mr. Adams is guilty of infringing the FIFA Code of Ethics. Thank you very much.
Thank you. Ms. Fayad, rebuttal, please.
Thank you, Madam President. So I would firstly like to state that if the appellant wanted to dismiss the Exhibit 5, so I'm going a bit back, it could have been easy for him to simply render his phone. So it is an act of bad faith from Mr. Atom not to have done that. And secondly, for the Amos Adam case, so I think that it's a pretty similar case to this one because Adamu actually asked for, I don't remember the exact number. He asked for money in exchange of votes for the FIFA World Cup. And he was banned and the CAS upheld the ban. So I think that it's pretty similar to the case we have in hand. And that's it for the rebuttal of the respondent. Thank you.
Thank you very much. Well, that rounds up all our oral submissions for today. Thank you to both parties. Now, as is customary at the closing of all hearings, I would like to ask both parties if they are satisfied that they've had a right to be heard and that the matter has been treated fairly and impartially by your three-member tribunal. So please, for the appellants, can you confirm that this is the case?
Yes, it has been the case, Madam Chair.
Thank you very much, Mr. Velásquez. Thank you. For the respondents?
For the respondent, we are satisfied with the proceedings of the hearings.